All right, let's get right into this. Picture a quiet community in Arizona, Mountain Gate. Seems peaceful, right? Well, a dispute over a simple roof turned into an all-out legal war. And this wasn't just about shingles and nails. Nope. This was a fight over the meaning of just a few words in a contract that every single homeowner there had to sign.
The entire battle really comes down to the community's rulebook, the CC&Rs. That's the covenants, conditions, and restrictions. And how you read that rulebook, well, that can mean the difference between a minor expense and a bill for tens of thousands of dollars.
So that brings us to the big question, the one that landed in front of a judge. When a roof just gives out, who has to pay for it? Is it on the person who lives in the house? Or is it the job of the Homeowners Association, which means everyone in the community chips in? Okay, so let's step into the homeowner's shoes for a minute. Michael Ludden's entire case was built on a pretty simple idea. A promise is a promise, especially when it's in writing and you're making the biggest purchase of your life. He was basically saying that from day one, everyone knew what the deal was. And here it is, Exhibit A for the homeowner. This is the line from a sales brochure. The glossy pamphlet they hand you when you're thinking about buying. It's not buried in some legal jargon. It's a straightforward marketing promise. And people definitely relied on that when they decided to move in. And get this wasn't some new thing. To make sure he wasn't misremembering, the homeowner actually texted the agent for the original developer way back from the 2000s, and the reply was crystal clear. Roof replacement is the HOA's job. That shows a consistent understanding that goes that almost 20 years. So, with those promises laid out, the homeowner's case then dives into the legal language of the CC&Rs, and it really all hinges on this one critical word, improvement. The official definition in the contract is super simple and broad. It includes any building, wall, or structure. So here's where it all connects. The homeowner's argument was just simple logic, laid out for the judge. 1, the rules say the HOA has to replace all improvements. 2, the rules define an improvement as a building. A house is a building, right? And a roof is part of that house. Therefore, the HOA has to replace the roof. Seems pretty open and shut. But hold on. The HOA saw things, well, completely differently. So let's flip the coin and look at their side. For the board, this wasn't about old sales brochures. It was about the cold, hard text in the contract and the tough financial reality their community was facing. And that financial reality, it's pretty rough. A board member actually testified the people were already paying over $3,000 a year in dues. And for what? There's no pool, no clubhouse, no gym, 0 amenities. Their big fear was that adding the massive cost of replacing 42 roofs would make dues skyrocket and absolutely crush property values. So the HOA's legal argument really zeroed in on this one distinction. They said, look, yeah, there's a general rule that talks about replace, but the specific section that's actually about roofs, it only says maintenance and repair. The word replace is just gone. And in contract law, the specific rule often beats the general one. This was the heart of their defense. And they had another ace up their sleeve. Back in 2010, the CC&Rs were amended to say that every single homeowner had to get their own insurance to cover the full replacement cost of their house. The HOA argued that this little change basically moved the financial burden for a huge disaster, like needing a whole new roof, off of the community and onto the individual owner and their insurance company. Okay, so you've heard both sides of the story. You've got the homeowner with written promises and a very broad definition of improvement. And on the other side, you've got the HOA pointing to a specific clause that's missing a word, plus that insurance requirement. So, before I tell you the outcome, if you were the judge, who would you say is right? So, how did this all shake out? After listening to everybody, Administrative Law Judge Nicole Robinson made her final call, and she settled this thing once and for all. And the verdict? It was decisive. The petition was granted. The judge ruled completely in favor of the homeowner. She found that the HOA is responsible for replacing the roofs when they wear out. So you're probably wondering, how did she get there? Well, the judge laid out this incredibly clear path. She agreed a house is an improvement and that the HOA had to replace those improvements. But the most brilliant part of her decision, honestly, it came down to the meaning of a single, everyday word. And here it is. This was the turning point. The judge literally looked up the word repair in the dictionary. And what does it say? To restore by replacing a part. Bam! All of a sudden, the HOA's main argument, that the word replace was missing from the roof section, it just completely falls apart. A repair, the judge decided, can absolutely include a full replacement. And to make her point impossible to misunderstand, she used this simple but honestly powerful analogy. She pointed out that the CC&Rs say homeowners have to maintain and repair their own windows. So she asked, if a baseball shatters a window, does the homeowner just slap some duct tape over the hole? Of course not. The proper repair is to replace the broken pane of glass. And that same logic, she ruled, has to apply to the roof. So yeah, one neighborhood in Arizona has its answer. But what does this ruling really mean for the millions and millions of us who live in an HOA? Well, it actually offers some incredibly important lessons. First off, it means those flashy sales brochures aren't just marketing fluff. They can be treated like a real binding promise. Second, it shows that a single word, repair versus replace, can literally shift thousands of dollars of responsibility. Third, it tells us that when contracts are vague, judges might just pull out a dictionary and use plain old common sense. And finally, and this is a big one, an HOA can't just wiggle out of its responsibilities because they're expensive. The rules are the rules. And all of that leaves us with one last thought. If you live in an HOA, you've got those same kinds of governing documents. They're probably sitting in a binder somewhere or in a file on your computer you haven't opened in years. But as this whole story shows, those documents are filled with promises and rules that have very, very real financial consequences. The only question is, do you have any idea what's in yours?